Dear viewers, today we shall be discussing the economic theory of contract. Let us introduce. In our everyday lives, we enter into several contracts, be it for the purchase of groceries, availing of services, purchasing property, or paying bills. Whether we realize it or not, we enter into numerous contracts in our daily routines. In a market-oriented economy, property and contracts are two core economic concepts that are regulated by the law. As per the law of contracts in India, an enforceable contract means the exchange of promises, offer, acceptance, and consideration are the three cornerstones of a legally binding contract. For example, X agrees with Y to sell his used car for ₹4 lakhs, or A agrees with B to supply goods in the future for a certain price. In both examples, there is an exchange of promises for a certain price known as consideration. In an ideal world, there should be enough safeguards to ensure that the parties perform their promises and the contracts can be enforced through the machinery of law if the parties fail to perform. Thus, from an economic standpoint, the law of contract is not only a device for facilitating the exchange of promises, but also for assigning risks between the parties. Typically, in contract enforcement, two questions are paramount. First, which promises are enforceable? And second, what should be the remedy for non-performance of promises? Let us come to contract theories. Theories are viewed as problem-solving devices. Each theory has its own advantages, which overcome the disadvantages of the previous theory. The study of how individuals and groups create and build legal agreements is known as contract theory. It examines the construction of formal and informal arrangements by parties with competing interests. The economic theory of contracts makes an analysis of the formation of contracts by individuals and organizations, especially when there is information asymmetry, due to the fact that many parties have varying motivations to carry out or refrain from carrying out specific activities. Contract theory incorporates concepts from financial and economic behavior. As far as contracts are concerned, there are various popular theories like bargain theory, efficiency theory, will theory, alliance theory, fairness theory, and consent theory. These theories have been classified into process-based theories, standard-based theories, and party-based theories. Now coming to bargain theory of contract. Process-based theories include bargain theory. The bargain theory was developed in the 19th and earlier 20th centuries to answer the first question: which promises are enforceable? A promise is legally enforceable if it is given as part of a bargain. Otherwise, a promise is unenforceable. Accordingly, the doctrine of consideration became important. That is, the promise made in a bargain for a promise for payment of consideration is enforceable. Let us take an example. You promise your friend that you will take him or her to a movie this evening. Now in the evening, you have forgotten or are not willing. Whether the performance of the promise can be enforced? through the machinery of the courts against you? The answer, of course, is no. The law does not compel performance in this case. Why? Because there was no bargain. Therefore, going by this theory, generally where there is a consideration, the contract is enforceable. And where the consideration is absent, the contract may be non-enforceable, even though the contract is clear and certain. This theory of contract has gained prominence and has found legal recognition in the Indian law of contract. Bargain theory answers the second question, which is, what should be the remedy if the promise is not performed? Bargain theory entitles the parties to the benefit of the bargain. Accordingly, parties may, in the contracts, provide specifically for compensation if the promises are not met. However, the computation of compensation is a tedious task, and the expectations of both parties in the contract are generally different, owing to information asymmetry. However, this theory has its own disadvantages. It does not recognize promises made without consideration. Under Indian contract law, there are exceptions when the promises are enforceable even when made without consideration. For example, a gift of property to a wife or son is enforceable by law, though there is no monetary consideration. Similarly, if a person finds my lost bag without any consideration, he is bound to return it, even though there was no promise. And if later on I promise to pay a reward, but I fail to do so, this promise is also enforceable, even though there was an exchange of promises. Another example can help explain another failure of this theory. Whether a promise to commit a crime in exchange for a promise to pay will be enforced through law. The answer, of course, is a big no. In this case, even though there is a bargain, an exchange of promises, consideration and certainty, the promises are not enforceable. Now let us come to will theory. Will theory and alliance theory are categorized as party-based theories. Proponents of the will theory are of the view that promises are enforceable because parties have expressed their will or willingly decided to enforce the commitments. The proponents of this theory believe that the law of contract enforces the will of the parties. Therefore, if one of the parties fails to perform the contract, legal force is justified because the parties intended for the contract to be fulfilled. However, this theory seeks to ascertain the will of the parties in each case, which may be extremely difficult because the inquiry will lead to identifying the real intention of the parties, which is extremely difficult to ascertain as a psychological fact. Coming to alliance theory. The alliance theory of contracts is based on the premise that contractual responsibilities are created by alliance on promises. Alliance theory contemplates the assumption of responsibility. In bargain theory, one party promises to do something in exchange for money or consideration, and there is an exchange or bargain of promises. In alliance theory, we will proceed on the assumption that I am to do this and you are to do that. And although I do not promise that I will do this, I accept the responsibility for your alliance on the assumption that I will and you will accept responsibility for my alliance in the same way. The effect of this is to create contingent liability in the event party does not perform. and party is assured that it will not lose out in exchange for promises. Now let us see consent theory. The consent theory posits that one cannot fully comprehend a contractual duty unless it is viewed as part of a broader framework of legal entitlements. According to this theory, rights may be unconditionally granted to another without any consideration, like a gift, or the rights may be granted subject to a reciprocal promise for the payment of money in exchange. This theory implies that the contract law deals with the distributive function of individual rights. Next, economic theory of contract. From an economic perspective, efficiency requires the enforcement of promises. If both the promiser and promisee intended enforceability at the time when the contract was made. This theory seeks to answer both the questions of which promises are to be enforced and what are the incentives for performance and remedies for non-performance of the promises. According to this theory, a promise should be enforced if both parties wanted it to be enforced when they made the promise and entered into a contract. Therefore, if the promiser is credibly committed to the performance of the promise should be performed. And this creates cooperation among the parties that is efficient economically and legally. Thus, according to the economic theory of contracts, the enforceability of the promise, which was intended by both parties to be performed at the time of making the promise, promotes cooperation and commitment. This theory recognizes that there is hardly any problem when the exchange of promises takes place simultaneously, but the problem arises when there are deferred exchanges. The theory is categorized as a standard-based theory of efficiency. For example, if you visit a mall and offer to buy something, the exchange of promises is simultaneous and there is no problem. However, in cases of deferred exchanges, where there is a time gap, the uncertainty and risk of non-performance pose problems for exchange. For example, A promises B to supply goods on a future date if B pays cash in advance. This is a case of deferred exchange. Take another example. A supplies goods to B and B promises to pay at a future date. Similarly, when A promises to supply goods in the future and B promises to pay in future for the delivery of goods, all these are cases of deferred exchange of promises. In these cases of deferred exchange, parties wanted enforcement of promises when they made them. However, there are inherent risks involved due to the time gap, and enforceability issues arise. If the supply of goods is deferred and the payment of goods is made earlier, the buyer risks not receiving the goods. Similarly, the seller risks non-payment if the goods are supplied but the payment is deferred. In these circumstances, the guarantee of performance through legal enforcement would promote cooperation and commitment and lend credibility to the promises and hence promote economic efficiency. The theory emphasizes that cooperation is productive. The concept of credibility in promises is critical. Many fruitful promises would be prevented from being made due to the dangers involved, assuming non-enforceability. Cooperation in the language of contracts involves carrying out the provisions of the agreement, while appropriation constitutes a contract violation. Contract law's primary goal is to make it possible for players to switch from games with inefficient solutions to ones with effective ones. Put another way, there will be motivation for people to fulfill promises that add value. Furthermore, an enforceable contract can change some games with a non-cooperative solution into games with the cooperative solution. So the economic theory of contracts is premised on the fact that there is an incentive for cooperation, a disincentive, and a net loss in appropriation. For example, if A agrees to transfer a property valued by him for a certain amount, say rupees 1,50,000 for rupees 2 lakh, and B agrees to purchase it at 2 lakh, believing its value to be rupees 2,50,000. If both the parties perform the promise, each party stands to gain rupees 50,000 each. Thus, there is an incentive for cooperation, and legal assurance of performance is an incentive. The economic theory of contract also takes into account the asymmetry in information. In real life situations, there is asymmetry in information among both parties. It is possible that both parties have differential information about what each party is expecting from the contractual relationship. There may be situations when one party possesses valuable information, but the other party may be unaware of such information. For example, A agrees to sell his land to B on a future date, say after 4 months, for a certain amount. B knows that the land is going to be very precious because there is a proposed national highway adjoining that land, which A is not aware of. This type of asymmetry in information can hinder the exchange of promises. Therefore, the contract law may provide for the disclosure of vital information in such cases, which will promote a mutually benefit exchange of promises. Now coming to default rules and transaction costs. This part, economic theory of contracts, also explains the default rules that fill in the gaps in the contracts. In a contract, various risks associated with the performance may be specifically stated, whereas some risks may not be stated, resulting in gaps in the contract. For example, many contracts stipulate provisions for risks involved in the event of delay in performance. However, some contracts may not contain anything in this regard. Similarly, take the case of a construction contract, where the contractor undertakes to construct a building of the design desired by the promisee. The municipal authorities disapprove and reject the design. This kind of a situation may be provided for in the contract, and the risks associated therewith may be allocated. However, this may not be foreseen, and a gap may be present in the contract. In many cases of deferred exchange, it may not be possible to incorporate all contingencies into the contract itself, or there may be cases where the contingencies likely to happen are not in the knowledge of the parties. Further, there may be cases when incorporating all future likely events would not be feasible because it would be too expensive. In all these cases, default rules of the law of contracts may be used to ensure the enforcement of the promises. In such cases, the gaps in the contract would be required to be decided by the courts, by following theory of contract. Performance of the contract. Economic theory of contracts answers the second question, which is, what are the remedies for non-performance of the contract? According to this theory, another important purpose of the law of contracts is to ensure optimal commitment to performance. Suppose the remedy for non-performance is the price paid by the person for breaching the contract. Now, if the price of non-performance is higher, the commitment to perform will be stronger. Therefore, price for non-performance and the cost associated with performance have a bearing on whether the promise will be performed or not. In the case of deferred exchanges, the time gap may lead to uncertainty as to the cost of performance. In a given situation, due to a time gap, the cost of performance may increase. During the time gap, due to the sudden rise in the price of raw materials, the performance of the promise for the promised consideration becomes more costly than the breach of the promise. Take an example. Suppose the cost associated with non-performance is less than the cost associated with performance. There is an incentive for non-performance, and the promiser will breach the promise. Similarly, if the cost associated with non-performance is higher than the cost associated with performance, there is an incentive for performance and a stronger commitment to performance. Now, coming to regulation of the performance of contracts by courts, let us take unconscionable bargain. Sometimes the contract terms or the promises made are unconscionable and irrational. For example, a person in dire need of money promises to pay the money lender interest at an exorbitant rate of 15% per month. The promise is unconscionable, and therefore the courts will refuse to enforce such a promise. Let us take caution. Suppose the making of a promise is not free and promise is obtained at a gunpoint. The contract law will not ensure performance in such a case, and the court may refuse to enforce the contract. Similarly, incompetence to contract. Any or all the parties to the promise may be minors or of unsound mind, and hence unable to make rational decisions because of unsoundness of mind or minority. The contracts entered into by them, therefore, cannot be enforced by the courts. Similarly, impossibility of performance. Performance may also be excused by impossibility, which is typically the result of an event that occurs between the time the contract was formed and the fulfillment date. For example, the goods might be destroyed by a tsunami or earthquake, and it has become impossible to supply them. Coming to violation of public policy. In certain situations, courts might decide not to uphold a contract due to the potential harm that performance would cause to the general public. Similarly, monopoly. Monopolistic conditions may lead to incredibly biased deals. The unconscionability theory enables judges to determine whether to put aside agreements that are obviously unfair. Alliance. As explained, the enforcement of the contract leads to cooperation and commitment. This leads to investment by both the promiser and promisee. For example, a farmer apprehending an attack by deadly insects on his crop wishes to buy insecticides and pesticides from a seller. The seller promises to supply an adequate quantity before the stipulated period for payment of a certain price. In pursuance of the order, seller procures the supplies to be supplied to the farmer. The farmer expects that due to control over insects and pests, his produce will be higher, and he invests in creating storage for the increased production. In this example, the seller invests in the performance of the promise and the farmer invests in relying on the performance of the contract. Both the parties invest their money, efforts and time. The farmer, relying on the promise, has invested in creating storage and has changed his position due to reliance on the performance, which increases the value of the performance for the farmer. This goes to another economic purpose of the law of contract, which is to ensure optimal dependence. Now coming to purposes of economic theory of contract. Minimization of transaction costs in contract negotiation and contract formation by providing efficient default terms and conditions. Secondly, motivating efficient disclosure of the information in the making of contracts. Thirdly, ensuring cooperation so that amicable and efficient solutions can be found. Fourthly, securing commitment for performance of the terms of contract. Fifthly, ensuring optimal reliance. Sixthly, ensuring long-term relations increases cooperation and decreases the requirement of reliance on formal contracts. Now let us conclude the topic. Property and contracts are the core economic concepts that are regulated by law. Any exchange, explicit or implicit, needs to be mediated by a contract of some kind. From an economic standpoint, a contract is essentially a device for resource allocation. The contractual component is typically minimized in spot trades, where the promises are enforced simultaneously. Economists' interest in long-term partnership has increased significantly in recent years, where there is a gap between the promise and the date of performance. A contract becomes a crucial component of the commercial relationships under these conditions. The economic theory of contracts answers the questions as to the efficient characteristics of contract law. With this, we come to the end of today's lecture. Thank you very much.